Stopa?
Your Honors.
Go ahead.
May it please the Court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes of time for rebuttal.
All right.
There are two reasons why this Court should reverse the final judgment of foreclosure and remand for an involuntary dismissal without prejudice. I want to start with the FHA argument. This is an issue of first impression in this Court, and one for which I submit the lower courts really need some case law. Since 1980, every state that has ruled in the country on this issue, including Florida, has ruled that in an FHA mortgage, the foreclosing plaintiff has to comply with HUD regulations in order to accelerate and foreclose. Every single one, and I cite those cases in my brief. I don't think my opponent even disagrees with that proposition of law, because the only thing that they argue in their answer brief is the legal issue of whether compliance with those HUD regulations operates as a condition precedent, putting the burden of proof on the plaintiff, or an affirmative defense, putting the burden of proof on the defendant.
But either way, Mr. Stopa, this was a bench trial, correct?
Yes, sir.
And what was presented before the court, you've raised, and I think, a denial in the answer and defenses. And I believe you basically indicate that there was no compliance with that and denied the condition precedent. I think that's what you've indicated. So I guess my question to you, I think since then there was affidavits from your client indicating there was no face-to-face. So at this juncture, whose burden is it to come forward to say, no, it would be the bank's burden then to show we've complied with this, or is it your burden to show that they failed to comply with this face-to-face meeting?
Well, I submit, Your Honor, that it's the bank's burden, it's the plaintiff's burden, just like it's the plaintiff's burden to prove compliance with paragraph 22 in a foreclosure case, just like it's the plaintiff's burden anytime there's a condition precedent. Not how it works under 1.120C, the plaintiff generally alleges compliance with conditions precedent, as it did. Then we specifically deny with the specific denial of HUD compliance in our answer, as we did. That puts the burden of proof onto the plaintiff. The Florida Supreme Court standard jury instructions for civil cases says that. The Boltby case out of BCA says that. The fourth DCA ruled on a couple of occasions in the foreclosure context that paragraph 22 is a condition precedent and dismissed where the paragraph 22 notice was not given. This court has ruled that paragraph 22 is a condition precedent. So to me, it's pretty clear that the narrow issue before the court is compliance with these HUD regulations actually a condition precedent? If it is, then it's really clear that the burden of proof is on the plaintiff. Now, I submit that there really, even though it's clear from all those jurisdictions, including Florida, that compliance with HUD regulations has to be done, okay, most of those cases emanate from the summary judgment context, and nobody has really addressed the question of does compliance with HUD regulations operate as a condition precedent, or is it an affirmative defense?
And I know you did a great job giving us national cases, but we have to be careful because, as you know, there's some that are judicial foreclosures, there's some that are non-judicial. But I guess the bottom line here, locally, the cases that, when I say locally, in the state of Florida, the cases that have addressed that, yes, they're a little bit different than the summary judgment contest, but most of them came to pretty much the implication is that it is an affirmative defense rather than a condition precedent.
Judge, I respectfully disagree. Those cases did not adjudicate the issue of whether it was a condition precedent or affirmative defense. The two Florida DCA's decisions...
I didn't say it did that, but the implication was almost that was treated as such.
Sure, and let me tell you how that emanated, okay? Those two cases, cite a case from the late 1970s called Cross. At that time, HUD regulations had not been codified into law. They merely existed in a handbook. So the fourth DCA, and they didn't exist as part of the party's contract. Okay, so at that time, the court characterized it as an equitable defense. Well, fast forward 25 years, the bank in the Knight case in the fourth DCA actually asked the court to rule that it was not a mandatory condition precedent, that HUD regulations were not a mandatory condition precedent. Even though the Homeowners Council did not file an opposing brief, the fourth district did not do that. The Fourth District did not do what the bank asked in that case, did not rule that it was not a mandatory condition precedent. And I submit that's just a matter of basic contract law. If you look at the note and mortgage, the note and mortgage have very clear language in it. For instance, the mortgage says, this security instrument does not authorize acceleration or foreclosure if not permitted by regulations of the Secretary. Well, that reads, and that same paragraph 9 also provides the remedies upon a default that says that the lender can seek payment in full except as limited by regulations of the Secretary. That is exactly how the paragraph 22 language is worded in the paragraph 22 Fannie Mae mortgages. It sets forth you don't get to accelerate or foreclose unless you give that paragraph 22 notice. And how do courts construe that? As a condition precedent with the burden of proof at trial on the foreclosing plaintiff, not as an affirmative defense.
And then
it's the same language.
And I understand that, Mr. Stoba, but tying into the facts of this case, regardless of whether it's a condition precedent or whether or not the affirmative defense, with respect to the specific facts of the case, after your client submitted the affidavits indicating that there was a failure of the face-to-face, Bank of America in this case never rebutted that.
Exactly, Judge, and that was part of my briefs. I submit I should have won this case at the summary judgment stage because we moved for summary judgment. We had an affidavit showing the counseling wasn't done and none of the 5 exceptions applied. That was not rebutted, and the lower court denied that without explanation. And I've given you circuit court orders showing about a lot of those granted by circuit court judges.
And as you know, that when we discussed before, circuit courts, well and good, and that's not really binding on our court.
I obviously get that, Judge. I cite that only because there's really not a lot of case law on this.
Yes, sir.
So I submit I should have won that at the summary judgment stage. And then when we get to, and mind you, that shows we've been litigating that issue as a condition precedent throughout the case. That's how it was pled. That's how it was argued at the summary judgment stage. Then we get to trial, and that's how it's argued at trial as well. It's argued as a condition precedent. I seek an involuntary dismissal after the plaintiff rests its case, saying you didn't comply with your burden of proof to prove compliance with this condition precedent. What did they do? Do they ask to reopen the evidence? No. Instead, they make the legal argument of, well, we say that that doesn't apply. And that was their only argument. When was the first time they argued that this was an affirmative defense? In appeal before this court. That was the first time. And so I presented some preservation case law on that issue as well, that they didn't even preserve the argument that this is an affirmative defense on the facts of this case. On the facts of this case, this was pled and litigated throughout the case through trial as a condition precedent. The bank simply chose to argue at trial that this did not prevent a foreclosure, that its failure to comply with the HUD regulations did not prevent a foreclosure. And I submit under the overwhelming cases that are out there, including from Florida, that argument was wrong. So
if we look at the statute itself in terms of statutory interpretation, tell me where in this HUD regulation it expresses that it is indeed a condition precedent, as opposed to 766, Med-Mal. Maybe your arguments about 559 has a little more language in here than in this HUD regulation. Where in that statute, if we just look at the plain language, does it express it's a condition precedent?
Judge, it's not in the regulation, but I feel like deja vu on the 559 stuff we did. But it's in the contract itself. Paragraph 9 of the mortgage does not even authorize acceleration unless the foreclosing lender complies with HUD regulations. There's no way to construe that other than as a condition precedent, just like this court has done on paragraph 22. The word condition precedent is not in paragraph 22 of the mortgage either, but that's how courts have routinely construed that. How on earth would it be different for an FHA mortgage when it's the same language? The party's contract says this security instrument does not authorize foreclosure if not permitted by HUD regulations. So this HUD regulation, it has to be done. They have to do it as part of their prima facie case. I look at the bank's brief where they try to argue otherwise. What are their case citations? The only case citation that they have is to cite a case called, an intermediate Ohio case called Goebel. Well, that was a motion for summary judgment case. I have 3 other Ohio cases that say specifically hold it's a condition precedent. I have a New York case from 2014 that holds it's a condition precedent. I have a California case that holds it's a condition
Well,
precedent.
be careful with California and be careful with Maryland, because those are non-judicial states.
And I totally get that, Judge. They're not perfect comparisons, but those are decisions that are persuasive that say that this is a condition precedent. I also, and I realize I don't limit the argument to that. That's why I have my circuit court orders. That's why I have cases from other states. That's why I make the analogy to paragraph 22. I mean, to me, the analogy to paragraph 22 is just so powerful. How could you, and I would ask your honors to challenge my opponent, how can paragraph 22 be a condition precedent, but FHA compliance be an affirmative defense when the language in both mortgages is the same? Not only is the language the same, but it's even the language that characterizes it with that limiting condition precedent language is in both mortgages. It's in the paragraph that sets forth the rights upon default. The rights upon default in paragraph 22, the right to accelerate, is set forth in paragraph 22, the same paragraph that requires the notice. Here, the paragraph that spells out the right to accelerate is paragraph 9 of the mortgage. That same paragraph requires compliance with these sub-regulations. They're really set up the same way. It's just what you have to actually do is different in the two circumstances, but they're conditions precedent in both. And I also cite some Florida law on just what constitutes a condition precedent, and to me, the language in these complies. Now, I don't want to spend all my time on the FHA stuff, although I'm happy to answer any questions there, because we also have, to me, another really clear basis to reverse, and that is based on standing. I cite a ton of let me start with this. To me, the case law, here's how clear the case law is. Look at what my opponent did in this proceeding, okay? I filed an initial brief. I cited all the case law on standing, and I cited facts like the original complaint didn't even have a copy of the note attached. It had a lost note count. They admitted they didn't have possession of the note. The original note was filed 2 years after the case with an undated endorsement. An assignment of mortgage was filed 3 years after the case, so they have nothing at trial showing standing when the suit was filed. And that was so clear they confessed error on standing. But
And here's the issue, Mr. Stoppa, because there's a case from our court that I think that they're trying to persuade us that perhaps there's been a shift in the law. A.S. Lilly. If we take your position, do we have to then recede from A.S. Lilly?
Judge, that's a hard question to answer. I spent a lot of time reading these cases.
Yes, sir.
I'd submit, you read the Eagles case that came out after A.S. Lilly. I respectfully submit there is not a way to reconcile those two in any materially distinguishable way.
And I was on the Eagles case.
I was going to try to persuade you with your own decision. Now, to the extent that there is intra-district conflict between those two decisions, the Eagles case is controlling. And there's also been 3 decisions from this court after Eagles that I filed the notice of supplemental authority on yesterday. All of the cases, A.S. Lilly is the only case that even purports to recede from the proposition that you could have standing after the suit is filed upon the amended complaint. But you have a bunch of cases both before and after A.S. Lilly that specifically say otherwise. That Eagles decision, Your Honor, was on. It's very clear that from the facts that the plaintiff had standing at the time of the amended complaint. But you still reversed a final judgment of foreclosure because it didn't have standing when the suit was filed, which is what all of the cases provide. You had the plaintiff, a foreclosing plaintiff, had to have standing when the suit was filed. In the Progressive case out of this court from 2005, the argument was made by that plaintiff, well, we didn't have standing when the suit was filed, but we did upon the amended complaint. That argument was specifically rejected in detail. And so if you look both before and after the A.S. Lilly decision, the case law is just overwhelmingly clear. I think it's clear that A.S. Lilly is the only case that can support their position, which is why they confessed error in the first place, and why that's the only case that they cite in their brief after the confession of error.
It's interesting too, Mr. Stoppa, because I guess you pronounce it FOCH case from our court, they certified a question to the Supreme Court of great public importance. And that's the case where Judge Alterman wrote his special concurrence, kind of supporting, your opponent's point of view that in this electronic age, it just seems, it makes more sense to go that route. But the Supremes haven't made any determination,
Oh, I would say that they have, Judge. And in that very FOC decision, Judge Altenburn cited the Florida Supreme Court decisions. Mariana is from 1911, and one of the reasons that Judge Altenburn and Focht and perhaps many other decisions, without explicitly saying so, why this court has routinely stuck to the principle of standing at inception is because the Florida Supreme Court required that in Vogues and Mariana. That Mariana decision has not been overruled by the Florida Supreme Court, and it was in the real estate context, and the holding of the case was that even where a plaintiff acquired standing after the suit was filed, not sufficient. They had to have it at the beginning.
And I think my question was, since that question was certified to the Supreme Court of Florida, the Supreme Court have yet to weigh in on this issue.
And I do agree with that. That's certainly true. Fox didn't wound up not going up to the Florida Supreme Court, and there hasn't been a case where it's gone up since then in the foreclosure context. But without that, what is the precedent that you have to go with? I submit that it's Vogues and Mariana, those Florida Supreme Court cases, just as this court did in Fox. I submit that it's your Eagles decision. I submit it's the 3 decisions that came out after Eagles that I did in my notice of supplemental authority. McClagan from August of 2014, Judge Wallace, you were on that decision. I submit there's also not a way to reconcile the fact pattern there with the A.S. Lilly decision. That's another case that goes my way on this issue. Progressive from 2005.
Well, even if we just look at this particular case, in Lilly, we know it was a bench trial. We don't know what testimony was proffered, what was adduced at trial. We don't know this particular testimony of the records custodian. But in this particular case, the records custodian, a lot of records were introduced. You stipulated there too. But was the bank's records custodian ever asked, when did the bank come into possession of the original note?
No, which is exactly the point, and it's their burden of proof, right? I mean, Judge, there are dozens of cases that reverse foreclosure judgments and remand for involuntary dismissals on this fact pattern. It is a dream fact pattern for an appellant's counsel doing foreclosure defense. I mean, you have an original note filed 2 years after the case, and an assignment of mortgage 3 years after the case, and the original complaint had a lost note count without even a copy of the note attached. That's a dream fact pattern under dozens of cases. And you have this one anomaly in A.S. Lilly that doesn't even cite any precedent really for the proposition, not even really, doesn't cite any precedent at all for the proposition that all of those cases can be undone, and now we can have standing at the time of the amended complaint. That concept is just not the law in Florida. So I submit that decision is not the one that should be followed here. You should be following the overwhelming authorities on this.
Mr. Stopa, I just want to let you know you're into your rebuttal time. You've got 3.5 minutes left, so you can use them as you will.
I'll save the rest for rebuttal. Thank you for letting me know.
Hold on just 1 second, ma'am. I've received a note that on the number 2 case, Coghill versus Green Tree, that Ms. Bosecker says she did not receive notice of the oral argument. Is the counsel for Green Tree, are you here still? Yes. I guess we won't go forward with the oral argument on Green Tree and Coghill at this point, and I just didn't want you to wait around and hold you up any further. So. Apparently not. Apparently not. So we'll let you know whether it'll be rescheduled for OA for another date, or if we'll just decide to determine the case on the briefs that have been submitted. Do you have a preference on that yourself, or?
Frankly, I would love to have the opportunity to argue today. He didn't show up. We both got served electronically with the notice. We both have a duty to check the docket. This is not the first time this has happened with this particular counsel.
All right, well, we'll, did you request OA, or did she request?
She did.
All right, well, we'll talk about that then, so if you want to remain, you can remain. I just didn't want to hold you up any further. All right, ma'am.
Good morning, Your Honors. May it please the Court, my name is Mary Walter, here for Bank of America as the appellee. I'd like to start with discussing the, second point, the first point on appeal, and that's the standing argument that we just discussed a moment ago with A.S. Lilly. We acknowledge that when properly challenged, standing is, of course, an important issue. There's a long line of cases that say that in the foreclosure context. But the fact is that we have A.S. Lilly now. That was decided earlier this year over the summer, and it is the reason that we did file that withdrawal of our confession. Because the withdrawal was acknowledged because we were permitted to file an initial brief, we don't think it's appropriate to perhaps penalize the bank for that. The A.S. Lilly case is a new decision that we have based this on.
Would you agree, Ms. Walter, that basically A.S. Lilly is almost like an outlier? Because since that case, you had other cases from our court taking the contrary view, that it has to be, standing has to be proven at the time of the filing of the complaint.
I would disagree with that slightly. I do acknowledge that as there are numerous cases that my opponent has cited that say standing must be since the inception, standing must be since the complaint was filed. However, I don't believe the majority of those cases have not addressed an amended complaint. And I think that distinguishes this, and I will further address that, but in this specific court, I believe that the decision in McLaren, it's cited in Alexis as Benz, but your decision, Judge Wallace, was I think the first amended complaint where this court held, we have to have standing at the inception. That may follow that long line of cases before it. However, I think it's still a step. It's a step to say that this amended complaint is not sufficient to establish standing. A.S. Lilly was decided after that. I think it's the next case in this court's jurisprudence that addresses an amended complaint where not just that the plaintiff dismisses its lost note count or proceeds to trial and files the amended complaint later, specifically takes that step to amend the complaint. A.S. Lilly is the second case that we have, and that's the case that comes out to the other way. Since then, we have had Eagles Masters. However, that case is respectfully not final yet because the bank filed that motion for rehearing that has not yet been addressed since July. So I think that it's somewhat of an open question, and A.S. Lilly is the most recent decision. I think that there have been decisions from other courts, notably the first, with Ham, and then before that with Cleafer. But again, we have just a few cases on this specific issue, so I wouldn't say that it's an aberration as characterized in the reply brief, but rather that it's simply a new decision in the law, and I think it's the proper one.
And you need that case to apply here because you'd agree with us that there's really no testimony been presented at the non-jury trial in this case, that there was...
Yeah, absolutely. We do acknowledge on this record that the note was admitted by stipulation. We'd note that
but the note being admitted, I don't understand why some attorneys in these mortgage foreclosure trials believe stipulating to the note, judicial notice of the note means materiality and relevancy and authentication in terms of when the note came into possession of the plaintiff. That's not what that means.
I understand that, and we do understand that generally.
But
however,
below, you never asked the records custodian, when did the bank come into possession of the original note? Because if you're arguing A.S. Lilly, you're going to have a statute of limitations issue. When can you file this amended complaint? Can you file it 5, 10 years later and say that you have the note? Where's the end?
In this case, I don't think that that's really an issue, the statute of limitations issue.
Well, initially, they filed a claim for
4
a
years
lost note which says we don't have it.
Mm-hmm.
We do not have possession of it. And as far as the case law is concerned, you, as the plaintiff, have to show that the original plaintiff had possession of it. How was that done in this case?
Well, so our argument is that we would have to show under A.S. Lilly that we had possession of the note since the amended complaint. And that's what we're arguing today.
But see, Eagles also cites other cases that are good law.
We acknowledge
They're
that,
not
yes.
in limbo.
Absolutely.
About you have to show that the original plaintiff had standing.
Yes.
You agree with that?
Aside from the decision in Ben's McLaren, I don't believe that those decisions involved an amended complaint. And I understand the language in those complaints in, I believe, McLean, for instance, the court, that's the fourth BCA case that's often cited, they say we have to have standing from the date the complaint is filed. And I acknowledge that that's obviously fairly clear. However, that case didn't involve an amended complaint. And because an amended complaint can relate back, I don't think it's a big step to go to A.S. Lilly and to kind of find that as the way a foreclosure standing and a foreclosure issue should be considered. We do acknowledge that there was no testimony in this case that the bank had the note since the filing of the original complaint in 2008. That's definitely a hurdle, a potential hurdle in this case that we believe is remedied by A.S. Lilly, which is why we have cited that in our brief and relied on that. However,
well, let me interrupt you. So if we conclude that A.S. Lilly really should be receded from, by virtue of the fact that there was a failure to provide any testimony regarding the issue of standing at the outset of this litigation, that in this case, then the bank loses, for a better word.
Yeah, that would preclude a judgment for the bank if there was, because there was no testimony in this case on that issue.
All right.
We believe, though, that A.S. Lilly represents, is completely on point and requires that this court find for the bank, because there was standing when we had the amended complaint. And we acknowledge that, Judge Sleet, to your point, that there was no specific testimony as to when the bank acquired the note at all. However, it was attached to the amended complaint, and when the bank started to ask questions of the witness regarding who the original lender was, that line of questioning, we had an objection. Your Honor, we have stipulated that the note be entered into trial. We should admit the note, and then this line of questioning would be duplicative because we already have the note in evidence. The bank's witness, or the bank's counsel, doesn't ask any more questions after that. So we believe that to the extent that we're arguing, is there evidence that the bank held the note on the date it filed the amended complaint?
Regardless of whether there's an objection or not, it's still the bank's burden to put this on the record. And I just don't want, I guess, to dovetail what Judge Sleet said, we read a lot of these transcripts now, and it's startling to think that a lot of these banks, they think just by submitting the note that's sufficient. You have to have testimony to indicate that they were the ones that had that note at the outset of the litigation.
Mm-hmm. Or an A.S. Lilly from the outset of the
And
amended
I understand your
But yes.
position that you're trying to convince us that A.S. Lilly ought to be the case that we should follow.
Mm-hmm.
I understand that.
Yeah, respectfully, we believe that the language of A.S. Lilly, the decision, is very much on point with what this case is. We had the original complaint that was filed in 2008. We had an amended complaint that was filed in 2013, and A.S. Lilly, it was 4 years later. Both amended complaints have the attached note, and then after a trial, we have a determination that the bank did not have standing where there should have been a determination to the contrary.
Was the attached note endorsed in blank?
In the amended complaint, yes.
Was there any testimony as to when it was endorsed?
No, not at trial.
Why not?
I was not the,
Okay.
That's not part of our record.
But you would agree that that's material, is it
It
not?
would be important for the attorney to ask those questions. However, in this case, it seems like perhaps he was precluded. But again, we only have the record before us, and it's a fairly short record, as we have acknowledged. We do believe that, as we said, that an amendment can relate back, although McGrath does hold otherwise. That is in the PIP context, and it's a different claim than a foreclosure.
I want to give you time to address
Absolutely.
the issue that Mr. Stopa raised in terms of the HUD regulation.
Absolutely. In that case, with regard to the HUD regulations, we believe that that is an affirmative defense. We acknowledge, again, that there was no testimony at trial regarding the HUD regulations. Your Honor brought up the motion for summary judgment and the affidavits that were attached to that. Certainly there were affidavits that indicated from the borrowers that they did not receive this HUD counseling. There was an opposition from the bank that discussed the fact that they had notified the borrowers in their paragraph 22 letter that they had the ability to do this. These were pleadings before trial, and the judge, for whatever reason, he doesn't indicate in his order, but he rejects the motion for summary judgment, and we proceed to trial. At trial, there is no evidence from either party as to whether there was compliance with HUD regulations, and we would argue that that is fatal to the borrower's case on this defense. Courts have long held that a condition precedent is an obligation that the contracting party must be performed before a contract can be effective, such as paragraph 22 in the Fannie Mae context. However, an affirmative defense is an avoidance of liability, and it alleges an excuse, perhaps a justification, or another matter negating or limiting liability, such as standing, statute of limitations, or waiver, those sort of issues. In Cross, the court did hold that HUD guidelines are not mandatory procedures constituting conditions precedent. That's the case that has been uniformly cited throughout the state. We acknowledge that the opposition by the borrowers, that they point out that this case was decided before the HUD guidelines became regulations. While that was discussed below, there's been no discussion in Cross as to whether that was part of the contract. And if it was part of the contract, which is why they would discuss it to begin with, then it shouldn't matter if they were guidelines, if they were in a handbook, or if they were a statute. We're still talking about what the contract says.
Let me ask, because Mr. Stoper raised that in his argument, I want to give you an opportunity to respond to it. He's analyzing, or he is using the parallel of the paragraph 22 with the HUD and
We
making
believe-
that
Absolutely.
similarity.
Yes,
What
we
are-
believe paragraph 22 is absolutely distinguishable. The paragraph 22 states, "The lender shall provide notice to borrower before it may accelerate." There's a very clear line there. The lender has to do something. In paragraph 6 of the note, it says, "If borrower defaults, then lender may, except as limited by the regulations, require immediate payment." And then it goes on, "In many circumstances, regulations may limit," and then it says the note does not authorize acceleration. These are very clear statements, and obviously why a lot of courts have decided that this is is an issue in a foreclosure. I mean, we're not saying in this case, and we don't believe it's an issue, but we're not saying that the bank doesn't have to comply with the guidelines. We're saying that this contract doesn't provide a condition precedent. There's nothing that the bank needs to do before it may enforce the contract. It's just stating for the borrowers, we're not allowed to proceed.
Help me reconcile the language in paragraph 9D in the mortgage with subsection B of the regulation. Because the security instrument does not authorize acceleration or foreclosure if not permitted by regulations of the Secretary. And if you look at the HUD regulation, subsection B, there must be a face-to-face interview with the mortgagor or make a reasonable effort to arrange such a meeting before 3 monthly installments are due on the mortgage, or 3 installments are unpaid.
I mean, I believe that
There's a face-to-face before 3
Yes,
installments are unpaid.
yes.
And then this tells you you can't foreclose if not permitted by regulations.
Yes, it doesn't necessarily put an obligation on the bank that the bank does not have to provide that in the contract. It's simply a defense. And as an affirmative defense, the borrower bears the burden of proof. And this is definitely an issue that the borrower could prevail on. Here, the borrower chose not to put on any evidence at all. They had the opportunity, they had their affidavits. They chose not to do that in this case after the trial court held that there was no condition precedent. Just because we don't have a condition precedent does not mean that the bank may foreclose. The mortgage is fairly clear that there is an issue with these HUD regulations, and that's discussed in the contract. However, the step to make this a condition precedent, like paragraph 22 of the mortgage, which specifically states the lender shall provide notice to the borrower, I think is a step that this court should not make, especially in line of our cases from Cross and then in Knight. As the borrower stated, in Knight, the bank did ask the 4th District to say the HUD is not a condition precedent. However, the court didn't say that. They say the bank asks us to say this is not a condition precedent. We have long held that this is an equitable defense. They could have very easily said the bank is wrong and it is a condition precedent, but they did not say that. They specifically said it was a defense. This is in line with a long line of cases from this court in Laws, Knight, and then we cited Madura from the Middle District. We also believe that the circuit court cases cited do not uniformly say that there's a condition precedent. Only 4 of the 15 cited use the language condition precedent. The rest of them find that there was no HUD compliance. That could very well be an affirmative defense that was prevailed on at a summary judgment hearing. It doesn't necessarily have to mean that there's a condition precedent. So the circuit courts are not as uniform as perhaps the borrowers have suggested. There is certainly an issue. We believe that with the decisions of Cross and then Knight, Laws and Madura, that there's clear authority to find this to be a defense as it should be, considering the language in the mortgage. Are there further questions?
None further.
All right.
Okay, we believe that that the trial court correctly decided in line with both A.S. Lilly and then Cross on both issues, and we would ask this court to respectfully affirm the decision below.
Thank you.
Thank you.
Mr. Stopa, you have 3.5 minutes remaining for rebuttal, sir.
Thank you, Your Honor. When I thought of this comparison between paragraph 22 and FHA, I thought there has to be a court that's seen this. There has to be. And I found one, and I cited it. Detweiler, out of Ohio, 2010. The Detweiler court rules that FHA regs, these HUD regulations in an FHA mortgage, are a condition precedent, and they make the very analogy to the paragraph 22 that I make. My opponent doesn't have any case law to the contrary. Her argument to Cross is just not well taken because she acknowledges that in Cross there was no discussion about whether those HUD regulations were part of the party's contract. It's basic contract law. The contract required that they do this before accelerating and foreclosing. They didn't do it. It's a condition precedent. So you can cite Detweiler as you write that decision. You're not creating that on a full cloth. There's another court that's agreed with that analogy. On the issue of
Quick thing, Mr. Stover, because
Yes.
if we go that way, we have to acknowledge the first, the third, and all of them coming to the conclusion, even though I understand you're distinguishing them in the procedural posture, that it was summary judgment as opposed to full trial, but language that's an affirmative defense, or it's equitable in nature, it ought to be an affirmative defense. So you want us to reject that line and focus on an Ohio case?
No, I don't think
And
you're
I thought the
rejecting them,
Ohio
Judge.
case-
I think those
Yeah.
cases don't call it an affirmative defense. Neither Laws or Knight uses the term affirmative defense. They call it defense, and that emanated from the Cross case, which existed, as the cases I cite in my brief show, existed before it was codified into law and not a term of the contract.
Because
Here's-
I've got Knight right here, and basically, in that case, as an affirmative defense, the Knight took the position that HUD needed to be complied. And here's what the court said. We have, I guess it was citing to Cross, we have held that noncompliance may be asserted as an equitable defense in mortgage foreclosure proceeding. And they seem to rule on that. So
Well,
help
I'm
me
sure
out.
you can see that they're not answering the question of whether it's a condition precedent or affirmative defense at
Correct.
trial. I'm sure you can see that. And to me, that's where you're not rejecting those two decisions, certainly not conflicting with those decisions. You're simply addressing a legal issue, the different issue. The different legal issue here is who bears the burden of proof at trial. Knight and Laws did not answer that question. They did not address that question. So I also submit I should have won here on the summary judgment stage, right? But going to the issue of standing, outlier is a great term. You used that term when my opponent was arguing. A.S. Lilly is clearly an outlier, and she tried to distinguish the cases I cite by saying, well, those didn't discuss an amended complaint. No, Eagle specifically, the fact pattern there showed there was standing at the time of the amended complaint, and you still ruled in favor of the consumer. McClagan, this court did the same thing with you, Judge Wallace. There was standing at the time of the amended complaint and still required it as of the inception of the case. Progressive did the exact same thing, specifically rejected that concept, and Focht. And then the first district in Ham and Kiefer, those were also decisions that had specifically addressed an amended complaint, facts with an amended complaint, and still found no standing was required at the time of the suit.
Before you run out of time, because I've been meaning to ask you this, and I want to make sure to give you an opportunity to respond. When you filed the affidavits on behalf of your client for the HUD, the failure to comply, I was able to pull it up, and this is one I'm questioning on. The bank filed an opposing affidavit indicating that, and it was paragraph 8, the demand letter attaches Exhibit C advises the defendants of the availability of HUD counseling and contact information for same. How does that play out throughout all of this?
Well, Judge, I've dealt with that fact pattern a lot, and the argument there that I think is dispositive is that subsection 5 of C5 of the regulation has the reasonable effort exception. To have a reasonable effort, you have to do two things. Send a letter by certified mail and make a trip to see the mortgagor at the mortgage property. That was the plaintiff's obligation in order to, under that subsection, to avoid the counseling requirement. Certified letter and a trip to see the mortgagor at the mortgage property. Their affidavit did not show that they did those two things. The mere sending of a letter does not obviate your obligation to comply with the counseling. So they did not create any issues of fact with that affidavit because all they showed is they sent a letter. They didn't show it was sent by certified mail and they made a trip to see the mortgagor. So they didn't show any of the 5 exceptions applied, and my summary judgment affidavit did show that the 5 exceptions did not apply. So my affidavit showed there was no counseling, showed none of the 5 exceptions applied, and they didn't create any issues of fact because they didn't show otherwise. The mere sending of a letter was not sufficient. And that's why they didn't even argue at trial that the mere sending of a letter was sufficient. So they didn't preserve that issue at trial either, because I think it's clear that the mere sending of a letter is not sufficient under the plain language of the regulation.
Mr. Stopa, you need to wrap up at this point, sir.
So I appreciate the court's indulgence, especially on the issue of first impression. I submit that either or both reasons are grounds to reverse, and I know that lower court judges would appreciate guidance from this court on who bears the burden of proof on the FHA issue. Thank you all very much.
Thank you both.
Thank you both. Let me go back to